afternoon, good evening. My name is Sainarayan, Bar Council Enrollment ID 2150406.
And my name is Sainarayan Ghosh, Bar Council Enrollment number 2150415.
And today we are going to teach you about registration of trademarks. Now, as attorneys at law, we often come across people who are creating new products, creating new businesses, and they always want something unique. And they always require their intellectual property to be protected. So, over the course of this video, we are going to teach you the basics of how exactly trademarks are, what are they, what is the basics of intellectual property, and then we will teach you the process of registering a trademark so that you can still come to us for business in case there is a problem. Next slide. Now, the Indian IP sphere has been evolving constantly. Necessarily, we see that one of the most notable amendments had come through our ratification of the TRIPS agreement, which is the trade-related aspects of intellectual property rights agreement of 1994. This has caused us to create the Trademarks Act of 1999, which has introduced several key provisions. The Trademarks Act also allows us to include registration of service marks, multi-class applications, extending trademark registration to whatever time frame we will teach you about, recognizing well-known marks, so on and so forth. Now, the thing is, before we actually had the Trademarks Act, we had a slightly outdated set of legislations. This included the Indian Trade and Merchandise Acts of 1958, and that was the predecessor to the Trademarks Act of 99 as we know it. Now, the thing about the Trademarks Act is, aside from the simple process of registration and the protections that comes with the Act itself, it allows for you to take legal action against trademark infringement and passing off of all lawsuits. Now, this leads us to actually understanding what is a trademark. If you think of a tick or of a flying puma, you will immediately think of Nike or the brand Puma. Sure, obviously, if you're a student, you will not think that the tick is present in your answer sheet. We all know how your academics are going. But regardless, the very fact that you can simply distinguish what that mark is a trademark. My co-counsel Deeptan will tell you a little bit more about this now.
Now, what are trademarks as defined in the Act? A trademark is usually a word, sign, symbol, or any form of graphics that is applied to a company, its goods, or services that it provides to distinguish them from that of its competitors. Now, for example, a brand, product, company name, or logo can be considered as trademarks. Like my co-counsel was explaining it to you, in the shoe industry, if we take up Nike and Puma, we have Nike's tick mark, which distinguishes it from Puma's pouncing Puma or the flying Puma through the different logos that it has. Now, what is the advantage of having trademarks is that it enables consumers to identify and purchase the products that they wish to enjoy and the services based on certain characteristics or quality of the product or that has been promised by the trademark holder or owner of that company. Now, my co-counsel will explain you the process for application of trademarks.
Down to the actual law aspect of this, over the course of the next few slides, we will be dividing our presentation into three important sections. Section 18, Section 23, and Section 25. Simple enough to keep track of. Section 18 preliminarily talks about the process of applying for a particular trademark and consequently how you must register it. Section 18.1 mandates that individuals claiming ownership on a particular trademark must file a written application. This written application is filed to the registrar of trademarks and it is filed according to the prescribed procedure as under this act. A single application can cover a multitude of classifications of goods or services with all of the fees that are applicable to such goods or services and all of the classes that arise from it, and the fees of which is provided under Section 2 of the Act. Now, when we talk about simply classification of goods and services, let's think of an entity like Apple. Apple creates an iPhone, which is a phone, iPad, which is a tablet, and MacBook, which is a laptop, all of which are different goods, and any services that come associated with it are also within the Apple umbrella. To protect the technology on each one of these, and will go into a patent. Well, however, to protect the Apple logo itself, that is the half-bitten apple in multiple classes of goods, will fall under this ambit. Furthermore, applicants, whether single or joint, that is, if I myself as a single applicant of a trademark or myself and Deeptayan as joint owners of a trademark are making an application, we must file this application within the geographical limits of the primary business location of our business within India. Let's say if our business is centered in Bangalore and all of our offices or our manufacturing units are simply over here, including our registered office, we must file our application for a trademark in Bangalore itself. On the contrary, however, if no necessary business operations exist, the application should be submitted within the jurisdiction of the designated service address. This is the address where you have usually registered the corporation on whose name you are trademarking your symbol. Now, subsection 4 of section 18 grants the registrar or the authority to accept, reject, or modify any applications for a trademark that comes to them, which are, of course, subject to certain constraints. Think of it as if I do file an application, the registrar has three things that they can do with my application now. They can either approve it in its entirety, stating that there are no changes required whatsoever, or they may reject my application at the very face of it, stating that this is not a trademarkable symbol or whatever. And consequently, there is a third one wherein they will accept my application subject to certain modifications which must be made to the application or the symbol which I am aiming to trademark. The catch over here is that the registrar does have a duty to inform you of the specific reason as to why any conditions are being imposed upon you. This means that when they do register or when they choose not to register by rejecting your application, or when they accept your application subject to certain conditions which the registrar is imposing upon you, there must be a detailed explanation for the same, including the reasoning and all of the materials that have been considered in reaching this decision.
So now I'll be taking you through the process of registration, which is mentioned under Section 23 of the Trademarks Act. Now, whenever you file a trademark, the applications are usually handled by the Office of Controller General of Patents, Trademarks, Industrial Designs, and Geographical Indications, which has branches in main cities of Mumbai, Kolkata, Ahmedabad, Delhi, and Chennai. Now, upon submission of a trademark application, the registry issues an official receipt containing the filing date and the application number for the registration. Now, the Indian Trademarks Office then conducts a thorough examination to ensure that the trademark that we wish to register is in compliance with the Trademarks Act. If any objections arise, the registry issues an examination report to the applicant. Now, the applicant must respond in writing or provide evidence of acquired distinctiveness. Like we mentioned earlier, every trademark should be distinctive from any other trademarks. It cannot have the similar uh, checkpoints of which match with other trademarks. Now, if there are any objections, a hearing with the examiner may be scheduled as a part of the process. Now, if the registrar finds that the trademark is eligible for registration, post the examination, a letter of acceptance is issued to the applicant. Now, the trademark is published in a journal which is known as the Trademark Journal, and a 4-month period is given for any potential opposition. If there are no objections during this period, a certificate of registration is issued. And in case there is an opposition, both the parties have opportunities to represent and present their arguments regarding the specific trademark. Now, usually a trademark registration typically takes around 18 to 24 months to complete, barring any objections or oppositions. Once it is registered, a trademark is valid for 10 years from the application date, and it can be renewed indefinitely after every 10 years on payment of the renewal fees.
This now leads us to section 25, which is about the duration of trademark registration. As Deeptayan has already pointed out, section 25 will outline the process of the duration of the trademark registration. And as he has also said, 10 years is the window that we're looking at. Subsection 1 of section 25 stipulates that upon receiving an application in the prescribed format within the necessary time frame after the payment of all of the fees in question, after all of your proceedings of the third party are all elapsed, the registrar may register a trademark for a period of 10 years. Registration can be renewed for another 10 years following the expiry of the initial registration or following the expiry of the already renewed registration that you have done before, however the case may be. Like Deeptan said, this entire renewal process is indefinite, only subject to conditions that are imposed upon you by the registrar itself. Now, before the final registration lapses, however, the registrar must notify the register proprietor accordingly that your registration is about to expire. Failure to meet the specified criteria within the notice period may lead to the registrar withdrawing the trademark for the register. Now, on the subject of what exactly these specified criteria are, this will be found in the notification that the registrar himself issues to the owner or the proprietor of the trademark in question. This will include the expiry date of the registration, the fee payment requirements, and more importantly, the conditions for the renewal of your trademark. If within this particular time the application is not submitted, then your trademark is taken off the register. If, however, an application is submitted in the prescribed manner and the requisite fee is paid within 6 months of the trademark's expiry, the registrar will renew the registration for 10 more years. If we revert back to the model where you simply did not pay up, the trademark is removed from the register due to non-payment of fees, and the registrar will only renew the registration within 6 months to 1 year, subject to you actually paying all of the penalties which are mentioned under subsection 3 of the Act of Section 25. Additionally, upon receiving an application in the specified form and payment in the specified fee, the registrar will restore the trademark and renews its registration for the next 10 years, and the expiry of the previous registration will continue into the next registration. As we've already said before, this renewed registration will take on for another 10 more years until you need to go through the same process again to make sure that your trademark is well protected.
As we all know, there is no such thing as a free lunch. In this case also, you need to pay an upfront cost for the registration of trademarks. Now, different costs applied to either single marks, series of marks, or collective marks, and the charges are levied as per the class. Now, for filing a single mark in a single class, the government fee for trademark registration is 4,500 per class per application for individuals, or the Department for Promotion of Industry and Internal Trade, that is the DPIIT registered startups, and any registered MSMEs. Now, for other entities, the government fee is 9,000 rupees per class per application. Additionally, registering a collective mark incurs a fee of rupees 10,000 per class per application. Now, when we are registering a mark in a convention country, incurs a basic cost of 10,000 rupees with additional fees for each subsequent class. Moreover, for global registration under the Madrid Protocol, the World Intellectual Property Rights Organization, or WIPO, imposes separate costs for registration in each member country of interest. Now, opposition and objection are related but distinct concepts in a trademark registration. Opposition usually arises from third parties. For example, if we take in the shoe industry, for example, if we take Puma and Nike, if there is any copy of any of the logo, then a third party can file for an opposition, whereas objection usually originates from the government. Now, the third party or competitors may lodge claims based against businesses seeking registration for using similar trademarks or any other symbols, often citing potential infringement of the intellectual property rights. Now, the legal fees for filing a notice of objection against a conflicted trademark application in one class amounts to rupees 2,700. Now, we will be talking about the trademarks registry. As we have told you, trademarks are usually registered in the office of uh, patents, trademarks, and geographical indications. Now, the Trademarks Registry was established in 1940, and then the Trademarks Act came into effect in the year 1999. Currently, the registry works as the operation or functional body of the Act. As a functioning body, the Trademark Registry implements all the rules, regulation of the trademark law in India. Now, the head office of the Trademark Registry is in Mumbai and it has branch offices in Delhi, Ahmedabad, Chennai, and Kolkata. A trademark is registered under the Trademarks Act of 1999 and it is then entered into the Trademarks Registry. In this process, the registry checks whether the registering marks meet all the conditions of the Act before registering it. Thank you, and we hope you all enjoyed our content.
And we also hope that if you do run into a problem with your registration, you can always approach Sainarayan and Ghosh, attorneys at law.